Update on prison education programs for confined or incarcerated individuals. Featuring Michael Cagle, Acting Director, Policy Innovation and Dissemination Group, and Ashley Schuler, Policy Specialist, Policy Implementation and Oversight.
Welcome to the Session 11 update on prison education programs for confined or incarcerated individuals. My name is Ashley Schuler, and I work in the Policy Implementation and Oversight Group at Federal Student Aid. I'm excited to present today with my colleague Michael Cagle to talk about the recent update to the regulations that will allow confined or incarcerated students enrolled in an eligible prison education program referred to as PEP to receive Pell. We are excited to share information about the process to apply for a PEP. Today, we'll spend a few moments discussing the PEP basics, including a brief history of the statutory change that brought us to where we are today. We will also provide some basic information about where to start when developing a PEP. We will also review the PEP application process to help you prepare for submitting an application to the department once you have a PEP developed and are ready to submit. We will review several frequently asked questions and answers about the PEP process and requirements, along with reviewing the PEP resources available to you as you begin the journey of helping confined or incarcerated students further their educational opportunities. So let's begin. On the next couple of slides, we will provide a brief explanation of the FAFSA Simplification Act that pertains to confined or incarcerated students and their eligibility for Pell. Additionally, we will provide key information that will help you as you begin this PEP journey. The FAFSA Simplification Act eliminated the prohibition that prevented students incarcerated in a federal or state penal institution from receiving a Pell Grant, but requires that an otherwise eligible Pell Grant recipient incarcerated in a correctional institution be enrolled in an eligible prison education program. Beginning July 1, 2023, otherwise eligible confined or incarcerated students in federal or state penal institutions who are enrolled in an eligible prison education program became eligible to receive Pell Grants. The law states that an eligible prison education program is 1. An eligible program offered by an institution of higher education, as defined in Section 101 or 102 A1B, is offered by an institution that has been approved to operate in a correctional facility by the appropriate State Department of Corrections or other entity responsible for overseeing correctional facilities, or by the Bureau of Prisons, is determined to be operating in the best interest of students, offers transferability of credits to at least one institution of higher education, and satisfies any applicable educational requirements for professional licensure or certification. An important note here is that a PEP must be approved by the department in order to offer Pell to otherwise eligible students. A school cannot simply take an existing program and begin enrolling and dispersing Pell to otherwise eligible confined or incarcerated students that enroll. However, it can work with its academic office and reach out to state or federal correctional facilities to either develop a new program or use an existing program and apply for approval of the program as a PEP. In addition, a school may offer a program to confined or incarcerated students that is not an eligible PEP. However, students enrolled in the program would not be eligible for Pell. How does an institution start developing a PEP? The process for developing a PEP will involve working with several partners both inside and outside of the school. This slide provides some key information that might be helpful as you prepare to develop a PEP. Although there will be many other areas that you may consider, we highlight a few important areas to help get you started. First, reach out to the state or federal correctional facilities in your area to gauge interest in partnering to offer a PEP. Work together to determine the specific educational needs in the community. Then develop a plan to structure a PEP to meet the needs of the community. Work with proper officials at the college. For example, your academic office and financial aid office, to develop and receive approval to offer the program to confined or incarcerated students. Develop a description of the educational program. It must include the educational credential offered, degree or certificate, and the field of study. Determine the classification of instructional programs, the zip code, related to the program of study. This information will be required when the institution applies for approval of the PEP using the electronic application for approval to participate in the Title IV programs, known as the EAP. We will discuss this process on the next several slides. Determine the method of delivery for the program and develop a plan to provide the proper infrastructure to support the delivery method chosen. Ensure that your program is consistent with your school's accreditation and any applicable state approval agency requirements. You will be asked to provide proof that you have been granted authorization to offer your program at the correctional facility. On the next several slides, we will provide more information about the eligibility of prison education programs and review each section of the PEP application form. We will highlight specific attachments that are required to be submitted along with the PEP application. Our hope that once we review the application with you, your institution will not miss important required attachments that could cause delays in the approval process. How does my school apply for a PEP? Schools must apply for PEP program approval using the electronic application to participate in the federal student financial aid programs, the EAP. Your school should be familiar with the EAP process since this is a system you use to report eligibility updates to the department. In addition to the EAP, a PEP application form is required. The form includes instructions and must be submitted as supporting documentation to the EAP. The department provides a link to the PEP application form on the Prison Education Topics page on the Knowledge Center. We will provide the link to this form as well as other helpful resources at the end of this session. I will now turn this over to my colleague, Michael Cagle.
Thanks, Ashley. Let's discuss the PEP application form. The purpose of the form is to provide a streamlined application process for institutions of higher education or post-secondary vocational institutions who are applying to the Department of Education for approval of a prison education program. The form includes the certifications and signatures that are required by regulation and instructions for submitting the required and optional attachments. The application requires coordination with the oversight entity, the Title IV institution, and other partners to ensure all required elements of the PEP are included. Collaboration and partnership amongst institutions, correctional facilities, oversight entities, and other stakeholders is so critical to the application process. We have been asked if schools participating in the Second Chance Pell experiment need to apply for PEP approval. The answer to that question is yes. All schools, including Second Chance Pell schools, must apply for PEP approval. However, schools participating in the experiment can continue offering their current Title IV eligible programs while they transition those programs to the PEP requirements. Second Chance Pell schools will have up to 3 award years under the experiment to transfer those programs to the PEP requirements. after 3 award years, the Second Chance Pell experiment will end, and a student must be enrolled in an eligible PEP in order to receive Pell Grant funds. An institution must apply to the department for approval of the first PEP at the first 2 additional locations. Then, additional prison education programs at the same location may be determined to be eligible after receiving initial approval without requiring further approvals from the department. These subsequent programs must still, however, be reported to the department, but do not require that same in-depth information that would be required for those first programs at the first 2 locations. Specific information must be included with the application, and we outline the specific information under our new PEP regulations, which is under 34 CFR 668.238. I'm going to provide a little bit of a summary of those requirements, and we'll talk more in depth about each of those requirements as we go through this presentation. But the first thing to remember is that you're going to be asked to provide a description of the program, including the name of the program and whether the program is a degree or a certificate program. You're also going to be asked to provide documentation from your accreditor that the program is approved and is included in your institution's grant of accreditation and approval. You'll be asked to provide the name of the correctional facility where the PEP will be delivered, and then also some documentation from the oversight entity that they have approved the program to be offered in that facility. You'll be asked to provide a summary of how the oversight entity initially approved the PEP. Now, the summary will include the intended methodology. You don't have to be exact, but just the intended methodology that you plan to use, including the thresholds, benchmarks, standards, metrics, data, and other information, and also how the oversight entity plans to collect that information, again required by the information in 34 CFR 668.238B4. You'll be asked to provide a description of the services that will be provided to these students, and you'll need to acknowledge that the Department of Education can limit or terminate the PEP's approval. And then the last couple of things you'll be asked to do is you must agree to submit annual reports to the department as required. Part of the requirements is that you submit annual reports, and we want you to acknowledge that as you apply for the program so that you're aware of it. And finally, you must submit documentation that the institution has an agreement with the oversight entity to obtain data about transfer and release dates. You're going to hear that quite frequently throughout the PEP process. The transfer and release dates is something that is going to be required, and that's by statute and regulation. As we mentioned, the department has provided a PEP application form to assist schools with the program approval process, and Ashley talked about that on the prior slide. But let's briefly discuss each section of the PEP application form and then highlight the required and optional attachments that need to be included with the application. You might find it helpful, not necessarily not required, but you might find it helpful to have the form in front of you as we continue this part of the presentation. And we did provide a link to the form on the resource slide on slide 32 of this session. But even if you don't have it in front of you, you can still follow along because we're going to provide some really helpful information for you today. So let's start with the very beginning. When you open up the PEP application form, it starts with Section 1. And Section 1 asks about general information about the Title IV school, as well as the oversight entity. And basically it's going to ask for the name and address of the correctional facility where you plan to offer the PEP and where it's been approved to operate, and also the contact information for all of the required entities, including the Title IV participating institution, the oversight entity, as well as the correctional facility. I'm going to highlight very important pieces of the application in each section and give you important reminders. And the very first reminder I'm going to give you is that all post-secondary institutions must complete Section 1. There are times when a section is not required, and I will let you know when those are. But for Section 1, all post-secondary institutions must complete it, regardless of whether it's the first program or if it's a program that you're just simply reporting that's subsequent beyond the first, at the first 2 locations. So in Section 1, we have Section 1A. And now in Section 1A, the institution will be asked to enter the contact information for the Title IV school. And typically that person might be your financial aid director. It might be somebody else on your campus who's going to be in charge of the implementation of the PEP. In Section 1B, we're asking the same type of information, but this time we're asking for contact information for the correctional facility. So the correctional facility where you're actually going to be providing the PEP, we need contact information for that facility. And then finally, in Section 1C, we're asking you to provide contact information for the oversight entity. So there's three different sections, A, B, and C of Section 1, that you need to outline the contact information. All right, now we can move on to Section 2. And Section 2 highlights the specific information that's required for all PEP applicants. And so again, Section 2 is required regardless of whether it's the first program or whether it's a first program at the first two locations or whether it's a subsequent program that you're simply reporting to us. So all post-secondary institutions must complete Section 2. And again, we'll start with Section 2A. The institution must be able to certify that it has no adverse action by an accrediting agency. And then in Section 2B, the institution must also be able to certify that it has no current or pending actions by the state to revoke a license or its authority to operate. In Section 2C, the institution must be able to certify that it has entered into an agreement with the oversight entity to provide transfer and release data. Remember, I talked about transfer and release data earlier. You're going to hear that quite frequently. And it's so important because that is a requirement that the facility needs to be able to provide that and needs to agree to provide transfer and release data to the department. It must also provide a summary of the agreement in the space provided on the form. And this is your second takeaway from that, besides the first one I told you about when a particular piece of the application is required to be submitted. This is another area that you need to make note of throughout the application process, and that is when there's space provided on the form, make sure that you complete that space. Don't leave it blank. We've got some spaces throughout the form where we require you to enter information. So in this particular case in Section 2C, you must be able to provide a summary of the agreement that you have with the oversight entity. We're just asking for a summary, and we ask you to enter a summary of the agreement in the provided space on the form. In addition to that, we also ask you to submit a copy of the signed agreement. And it's required to be submitted along with the application when you're ready to submit it. And that's going to be labeled as Attachment 1. The application is very clear that that's the first attachment that's required. And that's the signed agreement to provide transfer and release data. So you need to make sure you have the transfer and release data agreement as Attachment 1, and that's in Section 2C. Then we move on to Section 2D, and the institution in this section must provide the accrediting agency information and approval documentation. That should sound very familiar to you because when you apply for any type of eligibility update, you're asked typically to provide that type of information about, depending upon what type of update you're doing. But in general, you're asked to provide the information about your accrediting agency. And so this is required to be submitted and must be labeled as Attachment 2. So this is the second requirement. When you get to this section, you're going to have another attachment that is required. And that's your accrediting agency approval documentation attachment. Now, the type of approval documents that you'll need to submit are going to depend upon whether the program is the first PEP offered at the first two locations, if it's a subsequent PEP beyond that first PEP offered at those first two locations, or if the institution is adding a subsequent PEP that's offered by a new method of delivery. The form's going to alert you, alert the school of the specific accreditor approval documentation that needs to be submitted, and that's going to be contingent upon the box that you check on the form. So depending upon what type of application it is, whether it's a first program or whether it's a subsequent program or if you're having a new method of delivery, there's specific documents that you need to submit as Attachment 2. All right, let's discuss Section 3. And here we go with Section 3. Here's a caveat for Section 3. And this is about the additional institutional information. Now, this is one where you need to pay careful attention because post-secondary institutions will only need to complete this section if you're seeking an approval of the first PEP at each of your first two locations at the correctional facilities. Otherwise, if you're just reporting a program beyond that, this section can be skipped. It's not required. But for your first programs, this is a really important section because this really tells us, the department, the meat of your program. It tells you all the requirements that are applicable to the program. So very first thing to remember in section 3A, the institution must provide a description of the educational program offered in the space provided on the form. Again, that space provided on the form is so important. Don't leave it blank. Enter the description of the program in section 3A. The description must include the educational credential offered, whether it's a degree or certificate, and the field of study as well. And the details of this description must match with the information that you enter on the EAP. So remember, you're completing the PEP application, but you're going to be submitting that application along with your EAP, as Ashley mentioned in one of the prior slides. So just make sure that the information that you enter here in 3A of your application matches with the information on the EAP. That's extremely important. In this one, you may optionally include additional information about your program. So if you want to provide more information to the department about your program, anything you'd like, you can do that as an attachment 3. But however, attachment 3 is not required, only if you'd like to include something above and beyond what you entered in the space provided on the form. So it's an optional attachment 3. Then we can get to section 3B. Now again, in the space provided, your institution must provide a description of any of the partner entities that will be providing any part of the educational program. So let's say, for example, if your institution has entered into an agreement with a partner entity or entities to offer any portion of the proposed PEP, you must include a copy of the written arrangement to comply with 34 CFR 668.5. And you might be asking, why is that? Well, if you enter into, even outside of PEP, if your school enters into a written arrangement, it has to have a written arrangement in place. And so if you are going to partner with other entities outside of your own school to offer a portion of the program, the department needs to know that, and you need to make sure that you are in compliance not only with the PEP provisions, but also with the provisions of our written arrangements, which is applicable to all programs when you are actually partnering with another entity. And again, if you do partner with another entity to offer any portion of the PEP, you'll need to also include a copy of that written arrangement as attachment 4. Now, attachment 4, again, only required if you have a written arrangement. Otherwise, you don't need an attachment 4. So that's attachment 4 is optional and is conditional depending upon whether you have that written arrangement. Then we get to section 3C. And now in the space provided for section 3C, the institution must provide an explanation of the admission policy of the proposed PEP. Admission policy is so important, and we mentioned it in the regulation as well. But you'll need to include any restrictions that you might have regarding admissions of students, whether it be by the institution itself or by the correctional facility. Any requirements of the oversight entity, if the program leads to licensure or employment for a specific job or occupation that might typically involve prohibitions on the licensure or employment of confined or incarcerated individuals, you need to include that. Or if the credits are transferable to another institution. So a copy of that admissions policy is extremely important. Or you don't have to have a copy of it, but you need to enter your admissions policy in section 3C, and that's just in the space provided on the form. No attachment is necessary. Then we get to section 3D. In the space provided in this section, you'll need to provide an explanation of the types of services that you provide to the admitted students. And those type of services could include, they're not limited to all of these. They could include orientation, tutoring, academic and reentry counseling. But one thing about academic and reentry counseling that's important, if reentry counseling is provided by a community-based organization, and we'll refer to that as a CBO, then your institution must also include a one-page document that contains the name of that CBO, the background information on the CBO, as well as the types of services that the CBO offers. And so if you do have a CBO that you've partnered with, you'll need to include that information as attachment 5. And we really ask you to make sure that you include that as attachment 5 if you are using a CBO. The attachment is not required unless the reentry counseling is provided by a CBO. And then we move on to section 3E, and the institution must be able to certify that the credits in the proposed PEP program can transfer to another public or nonprofit institution by checking the appropriate box in the form. In addition to that, it must provide the name of at least one eligible institution that the credits can be transferred, and also a summary of the transferability of credits policy in the spaces provided on the form. Again, there's a space that you need to enter that information in the space provided on the form. I know I keep saying this, it's so important though. Don't leave it blank. Don't hold up your application. Make sure you enter information when requested. So if the institution has a written articulation agreement, it must also include a copy of that agreement as an attachment 6 for the transferability of credits. If the institution, further, in addition to that, if you have articulation agreements with more than one school or more than one institution, you must also include a listing of all the institutions with which you have an articulation agreement in the attachment. And I'll stress it again, although attachment 6 is only required if you have a written articulation agreement, your institution must provide at a minimum at least a summary of your transfer of credit policy. All right, now we can move on to section 3F. In 3F, the institution must be able to certify that the proposed PEP meets the licensure requirements in the state where your correction facility is located. Or in the case of a federal facility, the state where most students will reside upon release. And your federal facility, if you partner with one, they'll know what state that is. And so you'll need to coordinate with them when you do that. For section 3G, we ask the institution that they must be able to certify that it will not enroll a student in any program that's designed to lead to the licensure or employment of a specific job or occupation. Again, that typically involves a prohibition of the licensure or employment of formerly incarcerated individuals. You don't want to enroll a student in a program in which that student may not be employable, so that's something to keep in mind. If the institution chooses, it may optionally include additional information about this requirement as attachment 7. But again, it's only optional. You don't have to include an attachment 7, but if you do, you're more than welcome to do that. Then we get to section 3H, and that asks for information about the initial oversight entity approval of the PEP and the best interest of students determination. Now, this section is divided into two different parts. The first part, in the space provided, your institution must provide a summary of how the oversight entity initially approved the PEP. And that's important when we say initially approved. It doesn't have to be like a long thorough summary, just a summary of how the actual approval occurred for the PEP. So at a minimum, it must include at least a description of the methodology, including the thresholds, benchmarks, standards, metrics, data, and other information, and then how the oversight entity collected and used the information that's required by the PEP regulations at 34 CFR 668.238B4 when they approve the PEP. So that's part 1, the initial approval of the oversight entity of the program. Part 2 addresses that best interest determination. And here it's important, we're just saying the initial best interest. Ashley already mentioned that the best interest is required 2 years after the approval of the PEP. But for this particular purpose in part 2 here on this section 3H, in the space provided, you must be able to provide a summary, no more than a paragraph, that outlines how the oversight entity plans to assess each of the required elements that are outlined in the regulations under 668.241A1. Now keep in mind, this is not the actual assessment, it's just the steps that the oversight entity plans to take to be ready to evaluate the required items in 2 years. The institution, again, may optionally include additional information if they choose about the initial oversight entity approval or the best interest preparation. And if you do, you label that as attachment 8. And that's the oversight entity approval and the plan to prepare for the best interest. Again, not required. As long as you enter the information in the space provided, you don't have to submit an attachment 8. But if you'd like to and you have more information to share, you may do so as attachment 8. Let's discuss section 4 of the PEP application. And again, as we mentioned earlier, section 4, all post-secondary institutions and oversight entities must complete this section. So you can't leave this section blank. It has to be completed. So we'll start with section 4A, and this covers the institutional assurances. The institutional contact person, which is really the person that is submitting the form, and you've identified that person in section 1, that person must acknowledge and understand that the department can limit or terminate the approval of the institution to provide a PEP. You must also acknowledge and assure that it will not provide that it will provide the methodology by which the oversight entity made each best interest determination for the PEP. And then finally, you must acknowledge and assure that you will submit all required reports to the department as we prescribe in the federal regulations at 34 CFR 668.239. In Section 4B, the oversight entity contact person now, and we're talking about that person in Section 1 of the form that you've identified as the oversight entity contact person. That person must certify that the oversight entity has provided the approval for the institution to operate the proposed PEP in the correctional facility. So the oversight entity must also certify that it will provide the required best interest of students' determination of the proposed PEP through a feedback process that considers input from relevant stakeholders and in light of the totality of circumstances as described in the regulations at 34 CFR 668.241B. It's a regulation we mentioned a lot in this particular presentation because that's where the best interest piece is. And then we get into they're also going to be required they should consider the required information in 668.241A1 when we're talking about the best interest. Also, at the time intervals specified in the regulations and D and E of 668.241. And then also you need to remember that you need to acknowledge that you need to submit the best interest determination to the department no later than 30 days following the determination. Again, that best interest doesn't have to occur until 2 years after the approval of the PEP. But this is just telling you that this is what you're being prepared now, that you need to make sure that you do take into account the requirements for that best interest once it's required to be submitted. So finally, in this particular section, the oversight entity must also provide its certification that it will allow programs to reapply within a reasonable time frame if it's determined that the program is not operating in the best interest of students. And then you also, the oversight entity must also certify that it will maintain an agreement to provide, again, that transfer and release data with the institution during the existence of the PEP. Section 4C. Now, this is where we get to the actual certifications. So Section 4C, an authorized institutional official from the school, the Title IV school, must certify and sign the form. And then when we get to Section 4D, an authorized oversight entity official must certify and sign the form. And for both Section 4C and 4D, the key thing to remember about those sections is that the person that signs the form must be authorized by either the Title IV school or by the oversight entity to sign the form. And that's very important to remember. Then we get on now to Section 5, which is the last section of the application. When you're completing the EAP to request approval of the PEP, your institution must be sure to follow the instructions including in Section 5 because we really outline them to be very specific to the PEP approval requirements. So first, in the educational programs section of the EAP, the institution must provide the details of the PEP, including the appropriate title and credential. This is important when you're reporting the PEP for approval. The words prison education must be included in the title of the program. So let's use an example. Let's say the program is General Studies. So what you would enter is General Studies Prison Education as the title of the program. You will also be required to enter the classification of instructional programs, referred to as the SIP code, related to the program of study. You should be really familiar with SIP codes because it's something, when I say SIP codes, it's CIP. You should be familiar with those because you report those all the time if you're reporting programs on the EAP. You must also enter the program length details and all other relevant information required by the EAP itself. Now, in the locations section of the EAP, you'll need to report the additional location, the correctional facility as an additional location. And there you would enter the facility's official name after the pre-populated institution name that's in that section. And this requirement applies for correctional facilities even if the students receive instruction primarily through distance education or correspondence courses at that location. Now, one of the required documents that must be submitted with the EAP is again, the accreditation approval documentation. And as you remember, the types of documentation required depends upon whether the program is an initial PEP that requires full approval, a subsequent PEP that's being reported, or a PEP offered by a new method of delivery. We ask for this approval documentation in Section 2D of the PEP application, and here the institution must include the applicable accrediting agency documentation labeled as Attachment 2. You'll remember in the PEP application itself, Attachment 2 was the accrediting agency and approval documentation information. Remember, an institution will use the EAP to request approval of the PEP, and instructions for submitting supporting documentation are provided on the EAP. In addition, all supporting documentation that's required as part of the EAP, as well as attachments required for the PEP application. Remember, we talked about all those attachments that are going to be required and some optional. When you're submitting those, including the program application itself, you must submit that following the instructions in the EAP for submitting supporting documentation. So you're going to use the EAP instructions to submit the PEP form and all supporting documents when you're ready to submit the program for approval. Now, you might be asking yourself, what happens when my program's approved? What's the next step? Well, once your PEP is approved, you will receive what we call an approval letter and an updated eligibility and certification approval report, and we commonly refer to that as the ECAR. And so you'll get that new ECAR that will list the approved PEP. All right, so now that we've reviewed the PEP application, let's discuss some helpful hints about the process. So first, you need to make sure that and this is so important, make sure you report the correction facility at which the eligible PEP will be offered as an additional locations in the location section on the EAP, and make sure you use the facility's official name. Review Section 5 of the PEP Application Form because that includes additional instructions on reporting the eligible PEP. If you're applying for approval of the first PEP at the first two additional locations, make sure you complete all sections of the PEP application. If you're reporting a subsequent PEP beyond the first PEP at the first two locations, you're only going to have to complete Sections 1, 2, and 4 of the PEP application, because as you'll recall, Section 3 is not required in that case. You should plan to work with one of the department's eligibility analysts on the details of your application once you submit it. You may be asked to respond to specific questions or submit additional documentations throughout the process. Very similar to what happens when you do other eligibility updates via the EAP. If you are applying for or reporting more than one PEP, you must complete a separate PEP application form for each PEP, but you can report them all in one EAP submission. So you could have several PEP applications in one EAP submission. Just make sure that both the oversight entity and the school complete the information in Section 4 of each of the PEP applications. And also the school must submit a finalized copy of the agreement with the oversight entity, and remember, that's Attachment 1. You need to make sure that you have that signed agreement as Attachment 1. You must also submit the required accrediting approval documentation, and that's as Attachment 2. And then one thing to remember is that you must also submit, like you do with other applications and other eligibility updates, a valid state license or other state authorization. Submission of other attachments identified in the PEP application form are conditionally required, and we described that in our demonstration. But just make sure that if you are required to submit something as an attachment, make sure you do. But if it's optional, it's not required unless you choose to. And again, I'm stressing this, again, it's so important. Where space is provided on the PEP application form for a descriptive paragraph, you must enter that information. Don't delay your application because if it's blank, your eligibility analyst will reach out to you to get more information from you. So don't delay it. Unnecessary delays, you don't want those. And then report the name of the eligible PEP in the educational program section on the EAP. And as a reminder, just as we said, the name of the program must also include the words prison education in the title. And all relevant information must be completed as instructed via the EAP, and the name of the eligible PEP reported in the educational program section of the EAP must match with the information in Section 3 of the PEP application form. So now you have it in a nutshell, the PEP application process. So I'm going to now turn this back over to my wonderful colleague, Ashley Schuler. So Ashley.
We have received numerous questions as schools are beginning the PEP process. Let's review several of the frequently asked questions and answers that we have received. Question number 1. Do all education programs offered by an institution need to be approved by the department? A school needs approval for the first eligible prison education program offered at the first 2 additional locations. Schools are required to report other PEPs. Remember, the PEP application must be submitted for each PEP regardless of whether the institution is requesting approval of the first PEP at the first 2 additional locations or reporting subsequent PEPs. Question number 2. How does my school apply for PEP for approval of a PEP? A school must apply for approval of a PEP using the e-app. A PEP application form must be completed and included as supporting documentation when submitting the e-app. For more information, we suggest you review Electronic Announcement General 23-52. There is a link to the resource as well as many other helpful resources from the Prison Education Topics page on the Knowledge Center. We'll provide a link and review it on the last slide. Question number 3. My school already offers a Title IV eligible program in a local jail. Do we still have to submit a PEP application for approval consideration? Yes. If an institution would like to offer Pell to confined or incarcerated students, it must apply for PEP approval. However, if an institution was offering a Title IV eligible program to confined or incarcerated students at the local jail prior to July 1, it is not permitted to enroll new confined or incarcerated individuals on or after July 1st, 2023 in that program unless it converts the eligible program into an eligible prison education program. So what about the students that were enrolled in the program prior to July 1, 2023? A confined or incarcerated individual who otherwise meets the eligibility requirements to receive federal Pell Grant and was enrolled in an eligible program at a local jail prior to July 1, 2023 may continue to receive a federal Pell Grant until the earlier of July 1st, 2029. The student reaches the maximum time frame for program completion under the SAP requirements outlined in 34 CFR 668.34, or the student has exhausted their Pell Grant eligibility under 34 CFR 690.6E. Question 4. Can institutions offer post-secondary educational programs in correctional facilities that are not eligible prison education programs? Yes. Yes, they can, but students in those programs won't be allowed to receive Pell Grants. The concept of eligible prison education programs in the law is just for Pell Grant eligibility. The department does not ban schools from having their own education programs in correctional settings, including those that are not approved by the department or eligible for Pell Grants. Question 5. Are schools with approved prison education programs required to report the correctional facility as an additional location? Yes. Correctional facilities where PEPs are offered should be reported as an additional location. Important to note, the facility must be reported as an additional location even if the student receives instructions primarily through distance education or correspondence courses at that location. Question 6. Are schools required to offer courses using a particular method of delivery or mode of instruction? No. Classes offered to confined or incarcerated individuals through an eligible PEP may be offered in any format. If the classes are offered using distance education or correspondence, the schools must be approved to offer classes in those formats by the school's accrediting agencies or by the oversight entity if applicable. Any of these agencies or entities may also prohibit or restrict a method of delivery or mode of instruction. Although correspondence was not allowed under the Second Chance Pell experiment, there is no restriction under PEP. If your institution plans to offer a PEP program via correspondence and have all the appropriate approvals, you will indicate correspondence as the mode of delivery when you apply for PEP approval. Additionally, as mentioned in the answer to the prior question, a school that offers an eligible PEP at a correctional facility through distance education or correspondence courses will be required to report that facility as an additional location, even if the school is not otherwise offering instruction at the physical location. Question 7. When does the best interest determination need to be made? Within 2 years of initial approval, the oversight entity will be required to conduct a best interest determination, which includes an assessment of the required items under 34 CFR 668.241A1, an optional assessment of items under 34 CFR 668.241A2. After its initial determination that a program is operating in the best interest of students, the institution must obtain subsequent evaluations of each eligible PEP not less than 120 calendar days prior to the expiration of the institution's program participation agreements. The oversight entity may also make a determination between subsequent evaluations based upon the oversight entity's regular monitoring and evaluation of program outcomes. The department plans to issue more guidance about the best interests of students in the future. Question 8. Are schools with approved prison education programs subject to the 25% limit of regular enrolled students who are incarcerated under 34 CFR 600.7 A13? Yes. Schools risk losing eligibility for Title IV HEA funds if more than 25% of the school's regular enrolled students were confined or incarcerated individuals. However, under 34 CFR 600.7C, schools that do not currently have a waiver of this provision may apply for one through their regional school participation division after it has continuously provided an eligible PEP approved by the department for at least 2 years. Remember, the waiver to exceed the 25% confined or incarcerated student threshold is not automatic under approval of a PEP. And if the institution wishes to exceed the 25% limit, it may not apply until 2 years after continuously offering an approved PEP. We granted a waiver to some schools to exceed 25% of the enrollment of confined or incarcerated individuals prior to July 1, 2023. Schools that received a waiver prior to the implementation date of these regulations are not required to reapply for a waiver under the new provisions. However, the department will limit the growth of incarcerated student enrollment at those schools to ensure consistent program quality and adequate oversight. Effective July 1, 2023, we have limited the enrollment of confined or incarcerated individuals in any such school to 50% in the first 5 years. We may raise the cap to 75% if we grant an additional waiver after the initial 5-year period, again pursuant to 34 CFR 600.7. Let's review some resources available to assist with schools with the PEP process. The Knowledge Center includes many resources to assist with the Title IV requirements. The main resource for PEP is a prison education topics page that is available in the Knowledge Center. This page includes a wealth of information, and we have highlighted that information on this slide. The topics page includes links to all of our federal register notices, our Dear Colleague letters and electronic announcements, our PEP application form, the application for approval to participate in federal student financial assistance programs, the EAP, the 23-24 FAFSA for confined or incarcerated students, the English and Spanish versions, various PEP fact sheets geared towards the program approval process, accreditation requirements, and the Fresh Start initiative, to name a few. Links to the FAQs related to PEP, including accreditation, best interest determination, reporting requirements, student eligibility, and the application requirements. We encourage you to review the resource page on the Knowledge Center, as we will continue to update this page with new resources on a regular basis. In fact, you should book this page for future reference. We've arrived at the end of our session. We hope that this session provided you with a better understanding of the PEP process. We wish you the best of luck as you develop a PEP for confined or incarcerated students, and it is our hope that this session has helped you to become better prepared for the approval process once you have that program developed. Please reach out to pep@ed.gov if you have any questions about the PEP process. We hope you're able to review the other sessions from the conference and wish you a pleasant day.